Good morning and good afternoon, everyone. This is Andy Yost with the Capacity Building Center for Courts. Welcome to the March 15th All Call, CIP All Call. For those of you that are into Roman history, the March 15th is the Ides of March. It's the dubious day when Julius Caesar exited the world at the hands of his friends. So if you're into Shakespeare or Caesar, beware the Ides of March. For the rest of us, hopefully you're having a good day. We have some fun things planned today. We're going to do a couple state showcase presentations around quality legal representation, and I'm happy to inform you that we have several co-facilitators. So the good news for you is that you won't have to listen to me talk for a full 60 minutes, which I think both of us are pretty happy about. Let's do a real quick orientation around Adobe Connect, and then we'll get right into the meat and potatoes of what we're going to cover today. So I'll make this short and sweet since I'm looking at the roster of people that are on, and I think all of you, I don't see a single name on there that I haven't seen before. Maybe I'm missing one, but nothing stands out. Anyway, we're in a virtual room right now, an Adobe Connect virtual room. In the upper left-hand corner of your screen, you see a poll. It looks like a number of people have already responded. That's great. As you're settling in and kind of getting yourself oriented, take a shot at that poll. You get 3 choices. The question is, what topics would you like to see CQI workshops on in the future? So this is just good old-fashioned data collection by the Center for Courts to help us have our work steered by the CIP and the work that you all are doing. So thanks for doing that. In the middle of your screen, you see a slide deck. We'll use that kind of as a placeholder, but also a presentation tool today. On the right-hand side of your screen, there are a list of attendees. I remind you that you have the ability to chat individually with anybody that's listed on this list, whether they're a host, presenter, or participant. If you just hover your cursor over their name, a little menu will open up, and one of your options will say Start Private Chat. You can have a private chat with anyone in the attendees list, and we encourage you to do that. As you all know, a lot of work gets done on the side and on the periphery, so to the extent that you want to have private conversations with people, please do. Know that the chat box that you see in the middle of your screen will capture the chat that we're all engaged in, and that transcript will be saved. But any private chat that you have with another person, no one can see except you and that other person. So, and that transcript will not be saved, so it truly is private. Bottom left-hand corner of your screen, you see an agenda. It's a relatively straightforward agenda today. 3 items, and Christopher Church and Scott Trowbridge from the Capacity Building Center for Courts are going to lead that discussion. So what I will do is a real quick gradients of agreement just to make sure that we're all sort of logged in and that we have all of our functionality. So here's the question for today. There's an ongoing joke in the Center for Courts where mostly I'm the butt of the joke. And the joke is that Andy is the voice of CIP because I'm always at least opening up these CIP all calls. So I've been rattling my brain wondering if I should come up with like an introduction, you know, like good morning CIPville or something like that. That actually was it. So on a scale of 1 to 5, where 5 is Andy, leave it alone, let's just move on, and 1 is, yeah, I love good morning CIPville. I'd love to hear that every time I get onto one of these all calls. If you'll just type into the chat kind of where you are. 1 is it's a good idea. 5 is it's time to move on. I would appreciate it. Gotcha. All right. Kind of a mixed bag. Good. Yeah, I have 2 older brothers, so I can take a joke. And if you stacked it full of 5s, I'd be all right with it. Good. All right, it looks like people are having no problem at all filling out both the poll and interacting with the chat box. So what I'll do now is just stop talking, and I'll hand the microphone over to Chris. So Chris, are you there? I think you might be on mute.
Me?
You there, Chris?
I hope so. Can you hear me now?
Yeah, we can. Great, thanks.
Great. Sorry about that, and thanks, Andy. My name is Christopher Church. I'm with the Capacity Building Center for Courts, and I just want to spend a few minutes talking about how we can use data to inform our work around approaching quality legal representation. Before we get started, I just want to talk briefly about why we care about quality representation in the first place. I think we all know this, but this will sort of help us better understand how we can use the administrative data that we all have access to. So first, state intervention into the private life is one of the most heavily scrutinized state actions. In child welfare, this intervention happens for good reason, to protect children, but we still require careful oversight by the bench and the bar to make sure that any such intervention is warranted. And the courts have consistently told us that the right for families to be free from unwarranted government intrusion is among the most sacred of our fundamental rights. So in less fancy words, it's kind of a big deal. Also, child welfare is a highly complex legal field. It's governed by many state and federal laws and regulations. Appellate courts at both the state and the federal level have sort of weighed in on this framework and given us feedback. And then, of course, there's often many collateral issues that surface that may impact the likelihood of whether a child can be returned home safely or find a new family, issues such as housing, access to public benefits or other resources. And parties certainly need an attorney to help them navigate this complex system. Finally, high-quality attorneys are critical to ensuring that judges have all the information they need to make an informed decision that best serves our children and families. Of course, these are just some of the reasons we care about quality representation. There are many others. But what I want to try and do is connect our interest in improving representation to the idea that we can use data to explore the nature of that very problem. I do want to say before I get started that I think our exploration has to be one that's grounded in inquiry. So when we look at the data, what we have to ask is, what can these data tell us about how we are serving children and families, particularly in alignment with our values in the court system? And what can the data tell us about how we can improve justice for the children and families that we are serving? I think the data can and do tell us this, and I hope to explore this idea on this call just briefly in the context of the removal process. Removals are often the beginning of the legal side of a child welfare case. And again, given the fundamental rights that we talked about above that are at stake in these cases, we have a heavily regulated process requiring oversight by the juvenile and family courts. We see this in two main findings that are required anytime a child enters foster care. First, we ask a court to determine, based on the evidence, that it was contrary to the welfare of the child to remain in the home. This is a high bar. We don't just decide that it's best for the child to enter foster care. We need it to be unsafe for them to stay in their home. Second, we ask that the agency make reasonable efforts to try and mitigate that risk prior to actually removing the child, of course, unless such efforts would further harm the child. But we see this sort of this legal framework that really provides a lot of checks to balance out that intrusion into the home. Under this legal framework, then, I'm sort of always surprised by the variance we see in removal practices. And we see this variance both within a state, so in the different counties, in the different judicial circuits, in the different child welfare agency regions, but also across state lines. We see this variance nationally. And so I'm going to use Georgia as an example here. On this slide, we can see that the likelihood that a child enters foster care varies by a factor of more than 6 across Georgia's 49 judicial circuits. And Georgia isn't all that different from other states or even our nation in the terms of that variance. They just happen to make their data publicly available, so I can pull that most recent data to share with you and explore this idea. But it seems that something as simple as geography certainly influences the likelihood that a child enters our foster care system. And from my vantage, it's worth sort of exploring this variance in the context of children's experience once they enter our foster care system. And one interesting aspect that I've sort of learned about as I've looked at this data is the difference in practices among placing children in foster care for very short periods of time. So if we look at this slide, this is based on the 2013 AFCARS data, which is the most recent national data we have available. The 2014 was just released, but we didn't have time to process it for this file. But what you can see is this is the percentage of children removed that are discharged from the system within 30 days of their removal. And so what you can see is in one state, nearly half of all children removed leave that foster care system within 30 days of their removal. And then in other states, less than 5% of children leave foster care that quickly. Nationally, we have about 10% of all children removed that exit our system within 30 days of their removal. It's about 25,000 children. It's spend less than 30 days in foster care. Well, that's sort of interesting, and we can examine these data in a little more detail to better understand the sort of flight of these short stayers, these children that spend less than 30 days in foster care. And what I've got up on the slide now is a histogram, and what that tells us is just the length of stay in days for these children who spent less than 30 days in foster care. So we know they all spent less than 30 days, but we can kind of see how that breaks down. And what we see here is that the bulk of these children exit foster care much quicker than 30 days. And what we can actually see is that about a third of them were discharged within 72 hours of their removal. So they spent just 3 days in care before going home. More than half, or about half, were discharged within a week of their removal, and about 3/4 of them were discharged within 2 weeks of their removal. And during these short foster care stays, most of these children are being placed in what I would call a sort of stranger foster care placement, an unfamiliar environment. And what we see is that nearly 3/4 of them are placed in these environments, about 54% placed in a non-relative foster care placement, and 20% placed in a congregate facility, such as a group home or an institution or an emergency shelter. And not even 1 in 5 were placed in that in a home of a relative where they presumably have some sort of relationship or history. And at this point, some of you may be wondering how we piece all of these data together and what I'm trying to get at here, and why we sort of care about this narrative. And the reason that it's so important is because the research is really clear that when a child is removed from their home, even a home where they're being abused or neglected, that can traumatize the child. And furthermore, being placed in an unfamiliar environment like a congregate facility or a non-relative foster care home where they don't know anyone can and often does compound that trauma. So even when we intervene, just simply removing that child out of that home doesn't undo the harm that they've experienced and may even cause further harm. And so as we dig into this a little bit deeper, into this experience of these children that are spending short periods of time in foster care, we know that most of these children, again, about 3/4 of them, are discharged to the same home from which they were removed. So wrapping this narrative up, we know that around 10% of all children removed are discharged within 30 days of their removal. And we know that most of these children are spending their brief time in foster care in an unfamiliar environment. And the research is telling us that both of these experiences, removal and placement in an unfamiliar environment, can compound the child's sense of loss and may further traumatize them. Yet most of these children are returned home within a week or so of their removal, the same home from which a judicial finding was made that it was contrary to the welfare of the child to remain, and that reasonable efforts had been made, or couldn't be made, to prevent the removal. So as we think about how we might want to approach quality representation, I hope this example provides just one way the data may inform our understanding and sort of enhance our intuitions concerning areas we can focus on. Because quality representation of all parties is certainly critical to ensuring that removal petitions are properly vetted and granted only when absolutely necessary to protect the welfare of the child. Yet we have this cohort of children being removed, placed in an unfamiliar setting, only to be returned home within a week or so of their removal. And I would argue this cohort of children might very well benefit from our efforts in approaching quality representation. They provide a compelling narrative for stressing the importance of properly vetting these removal petitions, and we're sitting on data that can tell us all about the magnitude and the sort of dynamics of these short stayers that are in your state. Let me stop there. I'm happy to answer any questions. I know I kind of flew through that, but we've got some more.
No, I don't have Adobe.
So I'll be happy to answer any questions. Otherwise, I'll turn it over to Scott to lead us into the next session.
Thanks, Chris. So we'll open up the floor here for about 3 minutes, unless we need more time for questions that you all might have for Chris, and then we'll jump back to Scott's presentation. So if you have a question, you can ask a question one of a couple ways. One is you can click the icon on the top of your screen. There's a little person with their hand up. If you just click on that icon, you'll raise your hand and we can call on you. You can ask your question over the phone, or you can just type your question into the chat, and we'll read it out loud and answer it as well. The virtue of having it typed in the chat is that it's saved in the chat transcript, and so that it's a point of reference for us in terms of data collection about things that you're curious about or topics or subject matter that might require some more refinement as we go forward. So 3 minutes, I have my timer set. If you have questions just about this particular data set that Chris was describing, or how you might use this kind of data set to inform your own legal rep work, now is the time.
I see a question about whether we have any idea of how many of these kids had a deprivation petition versus not. I'm guessing, Matt, I may just do the good lawyerly thing here and answer your question with a question. I'm wondering or I'm assuming that maybe you're meaning versus a child that was voluntarily surrendered to the agency, or maybe one where law enforcement removed without first filing a petition. Is that getting at maybe what you were asking? Because in many states, I know that the child welfare agency doesn't even have the authority to remove. Law enforcement will remove, and to answer your question, I guess either way, we don't. What we've done in a number of states that I've worked in is tried to look at the removal framework and the landscape of how things are done in that community, and we get a much better idea what's driving this process. And that's sort of what we would hope would happen as we, dug into this sort of data in a state or in a local community, is trying to get a better understanding of what's happening on the ground there, and then get a better understanding of what's happening and see if there's actually something we can work on to improve it. And Kelly, I think the idea that how we would use this is, again, as you undertake your quality representation work, or really any project that you're doing on behalf of CIP, the way that I would see CIP programs using this is first to sort of try and identify areas where a CIP program can focus their efforts. So oftentimes I think when we look at the data, they illuminate these sort of issues that we may not have thought of or that we may not have seen. And that's one of the things that I think, that was certainly my experience in looking at this population here of short stayers. I just had no idea that this was happening. And from my vantage, I sort of look at this as some of these kids who are going home within 2 or 3 days, could those removals have been prevented? Maybe, maybe not, but that would certainly be something I'd want to dig in a little more. And if so, how would we have done that? Was it a matter of getting information to the court? Was it a matter of connecting families to services? In some states, I'm sure it's a matter of identifying relatives a little sooner. Again, the national data point to this being an issue where children go right back to the home from which they were removed. Of course, in other states, that won't be, in other states, it'll be something entirely different, where maybe some of those short stayers are really just going to relatives, and we need to figure out how we identify them more quickly to prevent those stays in those unfamiliar settings. I think I have a hand raised, which I think Scott, you can certainly ask a question now.
So I guess my question, just in context, are you suggesting that quality legal representation can help to prevent these placements? Or, as I look at it saying, if this is going to be addressed prior to the case coming into court, there's no legal representation until the case comes into court. Some of the reasons that children may be going back in a few days is because they had great, strong advocacy from a parent's attorney or the child's attorney to have the child return home rather than have the case proceed in a different direction. So I wasn't sure if we're saying, hey, let's look at how we can avoid these cases coming into court and having, of course, then a judge or a legal representative at all, or whether or not we're saying, hey, once it comes into court, here's how quality legal representation could help.
Yeah, I think I think what you're getting at is exactly what I would think the first step. And if you noticed in your community, whatever state or locale or region that you were in, that there were a considerable number of children that were spending very little time in foster care. Those are the very questions that I'd want to explore first with the stakeholders that are involved in this process. So just like you said, this could be indicative of having a very high quality representation process where they're getting good advocacy right up front and achieving a good outcome for their parties. And if that was the case, we would hope over time that those children would not be removed. I mean, part of the process here is if they're going home in 48 hours, it certainly raises the question of whether that removal could have been avoided. And so part of that is a feedback loop to the community saying, here's the parameters for removal. But I also agree that it may yield some other interesting information about the process. If attorneys aren't being appointed early, could early appointment help? And I think that comes down to learning whether the courts feel like they have adequate information at the removal stage. When these removal petitions come forward, one of the things that in one of the states I've worked in is that we've seen is that a number of counties, they have a court officer rather than a judge vetting that removal petition and making that determination. So it's a court staff member rather than a judge, and we've heard a lot of reasons why that may be happening. I'm not saying that that's causing the difference in the short stayers in those two communities, but that would be something that I think would be worth exploring. So I think your question gets right at where I would hope we would go next, which is to try and dig into this data and try and connect it to what's happening at the local level, and then think about how we might move forward from there. I hope that was helpful, or responsive at the very least. It's not helpful.
Great, thanks, Chris. And we'll have space, and we'll have an open space session at the end. So if there are questions that emerge during the remainder of the all call, hang on to them, and we'll open up the floor again. For the sake of time, we're going to jump back now to Scott and showcase one other state here. So, Scott? You might be muted there, Scott.
Hello, can you hear me?
Yep, we got you.
Right, double muted, sorry. So thanks, Chris. So what we're talking about today is just how you're approaching legal representation and through a CQI lens. And so Chris gave us a nice look at how you may have a lot of data already that can clue you into part of what's going on and that you can dig deeper. So now I'm going to interview two states who have gone through some CQI processes, some systems change around legal representation. And I really have two intents here. In one way, I want to showcase what they did because I think it's interesting as a substance. And another thing is we've been working on CQI a lot. You've been working on CQI a lot. If you look at the self-assessments over the last few years, there's a huge change there. But one thing we've been working with the Children's Bureau on is refining some of the tools that we've used for CQI. So the interview questions I'm going to go through are in phases and steps that will look pretty familiar to you. So, I think if you want to pay attention to that part of it too, just the different phases that have gone through these projects as well as that are still to come, and that they're in the New Jersey example, the cycle is very clear. So let me make sure. Stephanie, are you on?
I'm here. Can you hear me?
Okay, great. Yes.
Okay.
So how did you decide that you needed to improve child representation through improving their engagement in court?
Well, the first thing is that in New Jersey, our courts are led by our administrative director, and he has been a proponent through his entire time as a judge of having youth come to court for their hearings. So we had the leadership backing as the first part of it, We also have in New Jersey a statute that's been on the books for about 8 years that requires that youth be noticed of their permanency hearings. So we had the law there as well. So based on those two things being there, the statewide task force that we have in New Jersey decided that it was something that they wanted to tackle.
And what outcome or outcomes did you hope to change by addressing this?
Well, we obviously, when you work in this world, we know that it's important for the youth to have some say in what's going on with their lives. So we kind of took on the no decision about me without me is what we have been reciting. And that's basically, to say that it's important for youth to have a voice in what's happening with their lives. And aside from the youth, it's also important for judges and for attorneys to get input from the youth themselves in order to make better decisions about what's going to happen to these children.
And regarding forming teams to work on this effort, did you form a new team?
We did. So as I said, this is something that the statewide task force started looking at first. We developed a subcommittee that we called the Youth Participation in Court Subcommittee from the larger committee. And from there, we asked for volunteers. So we had the subcommittee, which had representatives from every stakeholder group. So we wanted to make sure that we had a representative for parents' attorneys, children's attorneys, the attorney for our child welfare agency, and the child welfare agency themselves, just to make sure that everyone was aware of what we were doing and to make sure that everyone had say in how the protocol was developed, which was eventually going to guide the implementation of this process in the state.
And for sake of time, I'm going to get this next question. Okay. So what was your theory of change?
Well, I talked a little bit about the fact that our director here, finds that this is an important initiative. So we had his backing. We also had seen some of the data from the other states. So we saw that it was helpful to have youth appear. And we wanted to improve the well-being of youth that were coming to court. And obviously due process is an issue also, to make sure that youth were having say in what was going on and to make sure that the judges were getting the best information that they could get.
So in developing a solution to this, what solutions, interventions did you arrive at?
Well, we developed a protocol which was very clear about the logistics that we needed to implement in order for this to happen throughout the state. One of the biggest concerns that everyone had was going to be transportation of how to get the youth to court. And a lot of people were also concerned about potential psychological impact that a youth appearing in court might have on them. So what we did is we developed a protocol that addressed all of those things: notification of the hearing, preparation, and debriefing after the youth appeared by their attorney, which in New Jersey we call the law guardian. And the law guardian's office also put together several what we call toolkits, which were basically a box of materials like pictures of court so that the child could see what to expect, games, puzzles, different sorts of things that could help the child get ready for court and engage them in the process. We also had several trainings here. We had a statewide training last year. We also had a few trainings focused on the counties as we started to roll it out across the state that talked about the protocol and also talked about the psychological impact concerns. And the other part that we did is that the law guardian's office worked with the ABA to develop a video for older youth that had basically interviewing older youth that had appeared in court and talking about their experiences.
Yeah, I'm familiar with that.
You are.
So in assessing readiness and building capacity, what was involved there with this effort?
So I talked about the protocol that we developed, and like I said, that protocol was vetted through our statewide task force, and then all the way up the chain of leadership. It eventually became an official policy for the courts in New Jersey that all youth are to be noticed of all of their permanency hearings. So we had also involved in the development of that protocol all high-level leadership from all the different stakeholders to ensure that we had buy-in from everyone and to make sure that everyone felt that they had contributed and that they had their concerns addressed.
And so the pilot started. What did you do when it actually started?
We piloted the protocol in 3 counties in New Jersey. So there was a large urban county, a medium, and then a small county that was more rural. So this was based on the different resources available from all the different stakeholder groups, as well as transportation and other concerns that we had. So we started in those 3 counties. In order to address concerns, we had kickoff meetings in the counties, which had all the stakeholders and leadership, again, to make sure that everyone knew that the leadership was on board with this. We met with all the stakeholders in each of the individual counties, along with a psychologist that we brought along with us who could talk about and address some of the concerns that the various stakeholders had before they implemented the protocol in those counties.
Okay, so you did collect data. What type of data did you collect?
We collected a lot of data. We had 5 surveys that were distributed at the hearings themselves. So we had a survey that was distributed to youth before and after the hearing, and it was just another survey that was distributed to all the stakeholders to basically gauge how everyone was reacting to the youth appearing. So the youth talked about how he or she felt before court and then after court, whether they felt that they had contributed, whether they felt that the judge had heard what they had to say, and the stakeholders provided information on whether or not they felt that the youth's presence was helpful to court that day. And we also had a monthly survey that was distributed via a link, which allowed a little bit more time for stakeholders to talk about the ways that they thought the protocol could be changed or modifications that could be made to help it work better.
I think we have some slides on that. So one of the things I would call a fidelity measure we had here was, were the children being prepared, and it was pretty surprising in my opinion. Near 100% of the youth, of course, this is just the youth that came to court, said that their law guardian, and then around 50% of their caseworkers had talked to them about what to expect in court. You want to talk about any of the other slides we have here?
I guess one of the other surveys that I guess is important to mention also is that we did have a survey that asked the law guardian to advise of why the youth didn't come to court if they didn't. So that helped us understand if there was a reason why, what it was. But we made sure that for every permanency hearing that we held, a survey was filled out either to tell us why the youth didn't come or for the youth to tell us how their experience was. So this slide tells us that what we found is that of the surveys from the pilots, which were 3 counties, 97% of the youth said that they were glad they came, and 99% said that they would come to court again. So that was obviously a positive benefit of implementing this, and we used those numbers as we rolled the protocol out throughout the rest of the state to show that this was a positive for youth and for stakeholders.
We looked at some of the benefits from the point of view of the other stakeholders. So for the next phase, so you were looking at the data from year 1, and you already mentioned quickly that you did expand across the rest of the states.
Right. So we piloted in 3 counties, and then about a year after that occurred, and once we were sure that things were going smoothly in the 3 counties, we rolled out to an additional 9 counties. across the state, and then a few months later we rolled out to the rest of the state. So at this point, as of August of 2015, the entire state has been notifying all children of permanency hearings, and everyone's been bringing youth to court. So we've continued to collect data, and we're actually closing out the surveys at the end of this month. But what we found as we rolled out across the state was very similar to what we found in the pilots, which was that the law guardians were preparing the youth and that they were having a positive experience. One of the things that we did once we rolled out across the state is we also changed the surveys. We modified them to make sure that we were addressing information that we needed. One of those pieces of information was the age of the child. So we found that a lot of complaints were based on the fact that some judges felt that infants couldn't really bring a benefit to court. So we collected data on how old the children were actually that were being to court, so that's something that we'll be looking at.
Great. And I think just given the time, a short time to talk about this, let's move on to any questions people have. There's some that are already in chat. Bridget Bowman asks, could you send the protocol to everybody on the call? And Beth Gilia says, is there court follow-up when the youth is notified but does not appear?
What we've done is we've required the law guardian to provide notice or to provide a certification or something to the court to show that the youth was noticed. In cases where the youth doesn't appear, we haven't really gotten into following up aside from the survey that I talked about where we're trying to find out why the youth didn't appear.
And we also had a question if there's evaluation of the pilot program available.
I'm sitting here hoping it doesn't time me out.
We do have preliminary data, which the ABA put together into an executive summary that I think we could send out.
Okay. Are there any other questions? Again, it's *6 to unmute if you want to ask over the phone. Well, Stephanie, thank you very much for letting me interview you. And I think we can move on. Arkansas. Kate and Brian, are you there?
I'm here. Brian, are you there?
Can you hear me?
Yes.
Okay.
So how did you decide to work on legal representation in Arkansas?
Well, excuse me, I'm in my throat. I've been the director of the program now for not quite 3 years. When I first came over, I had previously been a managing attorney with the agency, and before that a field attorney, doing these cases in the courtroom probably in about 75% of the counties across the state at one time or another. So I had the first-hand opportunity to see parent counsel in action. And when I came over, the one thing that I mentioned even in my interview and as one of my top goals was nobody ever came and saw parent counsel perform in the courtroom. They had no oversight. They had no evaluation. They had no feedback or input on how they were doing their job. So because we use a strictly independent contractor attorney system, I had to develop a evaluation protocol from scratch based on what I had seen and what I thought was good representation and what I thought we needed. So that's kind of what we did. There was some good attorneys out there that were doing good things. There were some bad attorneys out there that were doing bad things. And, of course, you get one or two performing badly, and you get a bad rap. And basically, the perception of the parent council program was that they were lazy and they didn't adequately protect their clients' interests and rights. And so we decided we needed to do something about that would include being able to help them correct the negative and enhance the positive and spread that as much uniformly across the state as we could.
So to get this off the ground, did you form a team to work on it?
Not necessarily a team. I'd already, like I said, I had a pretty good idea about what I thought was necessary and what we were going to do, and I worked with CIP and the staff here at AOC. They borrowed and stole some stuff from what the ad litem program was doing, brought some stuff with me as what we were doing as agency attorneys as far as what their evaluations were like, and then reached out to some other people who managed attorneys to get their buy-in, or to get their input, I should say, as to what to look for and how to do that. And we wanted to make sure that it wasn't, because the attorneys that we had in the field, some of them have been doing this for 20 years, and so we didn't want them to be too anti-evaluation, so we had to get out some messaging beforehand that it wasn't going to be a gotcha type of thing, but it was more of an improvement and enhancement type of thing. And so we didn't really have a team. We just kind of took bits and pieces and parts from other people and cobbled together what we wanted, what I wanted, and went with that.
So did you need any other data to know this was a problem, the lack of an oversight system?
No, not really. Like I said, I'd personally been out in the field and observed some of the things that were going on, and as an agency attorney, I took advantage of some of that during my time as the agency attorney. I knew parent council wasn't going to fight me on things, so I was able to get things into evidence that I probably shouldn't have got into evidence as an agency attorney, but I was representing my client at the time. I wasn't concerned with the parent representation. I was doing my job representing my client, and there were times you go home after that and you'd feel bad because you felt like those parents got taken advantage of, but that attorney was there and didn't do the job. So I had personally seen the holes and what needed to be fixed, and had a pretty good idea how I wanted to go about fixing it. So, oversight of the system is just justified anyway, especially nowadays in light of the, government transparency issues and how we're spending our money and what we're doing for these parents. So, like I said, I had a pretty good idea about how I wanted to go about doing it.
So what is your theory of change? You're still really in the midst of this effort. What are you hoping the changes you're doing, or the oversight system that you're building, how will that affect practice or children and families?
Well, it has a lot of impacts, because that negative reputation that I talked about earlier wasn't sustained within just the dependency neglect community. That got back to our legislators, and that got back to our community leaders, and that got back to other people. And so it was difficult to get increased funding or other things that we might have needed for this program when you go to somebody and say, I need this for my parent council program, and they're like, that's the one where you guys don't really do anything, kind of, that was the feeling out there, that parent council were just basically holding a chair down. And of course, good parent council representation has an impact on multiple parts of the case. How fast you reunify, outcomes for parents, outcomes for families, and of course, when I mentioned it got back to our legislators, that had a potential impact on our bottom line and our budget. So there were a lot of things to consider when we were putting that together.
the solution was to, in as far as the phase being developing or select solutions, the solution was an oversight system. But what are some of the aspects of that that are more like interventions, like what, building a data collection system? I think people understand that, but when you have some data as you're collecting it, what are some of the actions that you've taken that might be more of a traditional intervention?
Well, our evaluation system that we have now it's a 5-part evaluation system. It involves court observation, a review of their files. They also do a self-evaluation. We have peer and stakeholder surveys that ask how our parent council are doing, and then we have use of the data that allows us to look at various timelines and things. In addition, we also have a policy manual that was developed in conjunction with the evaluation process that sets standards for our employees, and when they sign the contracts, there's an addendum that they sign, noticing that they received a copy of the handbook, and they're expected to uphold those reasonable practice methods. And then we also here in Arkansas have a Supreme Court derived document called Administrative Order 15, which has what they deem to be minimum practice requirements for anybody who does parent council work. It also covers dependency, neglect, attorney ad items, as well as domestic relation attorney ad items. So we took all of that and molded that all together, and those minimum standards and best practice type things are what we expect out of our attorneys, and that's reflected in the evaluation pieces.
And you have corrective action meetings or plans within this?
Yeah. Once all 5 pieces of the evaluation have been completed, we bring in the attorneys individual one-on-one, 3-on-1. They sit down with our management team, and we go over their evaluation, and we talk about what we think they did well. We discuss their data, their timelines. For instance, we have multiple jurisdictions that have several different parent counsel in it just because of the coverage issues that are required. So if we see one parent counsel that's having cases where their timeline to reunification is 30 or 60 days longer than everybody else in the jurisdiction, obviously that's a red flag to us that something's going on with that attorney. And so we talk about why their cases are taking longer to get to reunification, or why they're taking longer to get to CPR or whatever the measuring stick we're talking about. And so we just kind of discuss with them what they do as a practicing attorney. Now, we're not dictating how they try their cases by any means, but we do talk about, the other attorney in this jurisdiction who appears in front of the same judge uses this technique or this method. Have you ever thought about trying that? That kind of approach. So like I said, it's not a gotcha, it's a building moment.
And beyond the one-on-one interventions, the parent counsel and ad litem attorney evaluations help guide training opportunities for the group as a whole. So every year we do a big Children in the Courts conference, but then also the attorney programs have their own fall conferences where they're able to kind of tailor some of the training to what they're seeing in the field. And then we've also just started a program with NIDA, the National Institute for Trial Advocacy, and we're doing a joint training with the parent counsel, ad litem, and agency attorneys. And we're training everyone as a court team on trial advocacy skills. And because of the size of it, we've had to break it down into essentially 3 groups. That way everyone can get the training. And we just had our first group, went through the training in January, and we've had really great feedback from that.
Okay, we're running low on time, so I'm going to skip ahead if that's all right. So let's just skip ahead because let me just sum up to say you've started this evaluation program, but you're not really to the end of the whole cycle of these questions we have. When will the first year or phase, I forget which it is, of this be done?
By the end of this fiscal year, which is June 30th, we will have evaluated every attorney on the roster, at least once. And
so then you'll circle back to think about what you can do to refine the program and expand or change. And do you have any ideas already about what you think you might want to do?
Well, we'll probably, we're definitely going to continue the program. We found that the feedback we've gotten from our own attorneys has been positive. They felt relieved to have the support that they didn't feel like they had prior, that someone was actually caring about what they were doing. And it's helped shape our training, as Kate mentioned. We've been able to pinpoint some broader scope training issues that affected attorneys across the state. So we'll continue to monitor our data to see where those training opportunities come up, and then we'll refine our process a little bit as far as what questions we ask ourselves when we're in the court watching. If there's an area that we deem that everybody seems to be above average or competent in, we might focus less on that and look at something different, because when you're in there doing the evaluation, it's difficult to keep track of everything that's going on because some of these hearings move pretty fast. So you can only take so many notes while you're sitting there, but it'll help us focus the evaluation more and dig deeper into perceived problems or maybe systemic issues that develop as a result of that.
Well, thank you all for taking the time. Let me interview you. If we have any questions, again, it's *6 to unmute, or if you can talk in the chat. From Kelly, wondering if you can share the evaluation protocol.
Yeah, sure. I'll be happy to. I think I sent you some of the documents I have. Some of them will be a little bit more difficult to send out because they're embedded in other programs like SurveyMonkey, so I'll have to transfer them to a document I can put into a PDF or something, but I'll do that.
What other questions do people have? Okay, I think turn it over to Andy again.
Yep, got it. Thanks, Scott, and thanks for all the co-presenters for their substantive contributions. One closing comment I want to say about the presentations that you just saw is that clearly there was substance that was discussed from Chris's sort of focused look on how you can use some administrative data that's available to you, to the two-state showcases. And one of the things that I wanted to highlight on behalf of the Center for Courts is the 5-phase framework that Scott used to frame the discussion. And those are just 5 basic CQI steps that most, if not all of you, are very familiar with. And I just want to point out that from the Center for Courts perspective, that's a framework and that's a vocabulary that we use a lot internally. So that won't be the last time, if it was the first time, that you've heard that kind of language or that you see those steps. So I encourage you to speak with your liaisons about the sort of change management process and sort of how you can think about it in these 5 phases that sometimes you engage in a nonlinear fashion, but we have these guiding tools that we use to move and integrate CQI into your work. So know that resource is available to you and your liaisons are specialists in using that framework. So what we'll do now is save about the last 4 minutes for open space Q&A. So again, what we'd like to do here is invite you to ask a question one of 2 ways. You can ask a question using the raise your hand icon, or you can ask a question just by typing it into the chat. And this truly is an open space. So if you have any question at all for the Center for Courts, we're happy to answer it. If you have questions for each other, feel free to ask those as well. They don't have to be limited to anything that we discussed today. So I'll set the timer now for 3 minutes and invite you to ask any questions that you might have. While you're stewing on a question that I'm sure you have, maybe this would be a good time for us to give you a little teaser for next month's All Call. And actually, maybe Eva, I think you're on the line, or if you're on the line, could you say a little bit about what next month's All Call is going to be? If I remember right, it's the APLA and older youth provisions of the Preventing Sex Trafficking and Strengthening Families Act.
Hi, this is Eva. That is exactly right. It's just going to be a look at some of the APLA provisions and what they mean for courts and attorneys.
Great, thanks. So if that is an issue that you're working on, you want to make it a point to tune in and kind of poke around with us a little bit on that issue and see what there is to learn. Leave another minute or so here for any questions in the open space. Right, looks like there's a little bit of conversation going on in the chat box here. Great. And Scott, I'm going to shoot you a couple documents I just did in an email that Stephanie referenced during her presentation. So while I'm closing out the call with the polls, if you could upload that to the files pod, that would be great. I'm going to jump over to the polls now. And you might have to drop the files pod back in. I think you do. So, all right. Well, on your way out the door, we'd ask that you respond to just a couple polls here, and Scott's going to drop in those files. So if you were interested in the protocols or the executive summary that Stephanie mentioned during her presentation, we'll get those uploaded as well. To download the files in the pod, just click on the file and then the button, download file button will illuminate. Click on download file, it'll drop it into your download box on your computer and you can have it to review. So there's some tool and information sharing live on the CIP All Call. We'd also like you to respond to the 2 polls, as you can see a number of you already have, which is great, that are in front of you. On the top left-hand corner, it's a short answer box, so if you'll just type in your answer, that'd be great. The question is, what additional guidance or products would you like from us at the CBCC to build your capacity to implement and evaluate quality legal representation? So they don't have to be, if you have typos or sort of incomplete but rough thoughts, go ahead and type them in there. It doesn't have to be, something Socrates would say. What's important is that we capture the information from you and use it to inform our work going forward. Secondly, if you'll respond to the pod that says you've heard a little about approaches to quality legal representation, were interested in how useful this all call was for you, that would be very helpful as well. So we're constantly trying to refine our process during these all calls to make sure that they're valuable to you. So if they're not valuable to you, let us know, and we'll keep playing around with the design to make sure that we're bringing something useful to you each and every month. So we have just about a minute left here. Actually, we don't have a minute left. So once you have responded to the polls, you're free to go. If you have a question or you want to hang on in the chat for a little bit, I will stay on the line for another 5 minutes or so. Otherwise, thank you very much for participating today, and we'll see you next month.